Good afternoon, everybody. It's great to have you with us. This is the Carlton Fields team, and you are joining us for the California Consumer Privacy Act. Are you ready? My name is Joe Swanson. I'm the chair of the firm's Privacy and Cybersecurity Practice Group. I'm a shareholder here in the Tampa office of Carlton Fields. I'm joined by three of my colleagues this afternoon who I'm very pleased to give this webinar with. And we want to thank all of you for taking the time to join us today, and we hope that you and your families are staying safe and healthy. Without further ado, we'll move to our panelists and their biographies. First and foremost, Christina Gagne is a shareholder in our Los Angeles office. She's an experienced technology lawyer whose practice focuses on cybersecurity and privacy, blockchain technology, technology transactions, and intellectual property. Christina advises clients on a variety of privacy regimes, including the European Union's GDPR and the California Consumer Privacy Act, among other things, and she handles data breach investigations and response. Next is Steve Blickensderfer, who is a technology lawyer and certified information privacy professional in our Miami office. Steve routinely advises clients on a range of data privacy and cybersecurity issues, from breach preparation and response to regulatory counseling and advice, including in connection with the CCPA. And finally, my colleague Mike Yeager is a shareholder in our New York office. Mike is a member of the Cybersecurity and Privacy Practice Group, as well as our White Collar Practice Group. Mike was formerly an assistant United States attorney in the Eastern District of New York, where, among other things, he was that office's computer hacking and intellectual property coordinator, which I think is very germane to today's discussion. So thanks for joining us, Mike, Christina, and Steve. Let's move to the next slide. This webinar has been submitted for CLE Credit in California and Florida. Those of you joining us from New York may use the California or Florida approval codes for credit in that state. And if you have any questions about CLE Credit, please reach out to Ben Kent, our colleague, whose contact information appears on this slide. And just a reminder to everyone that this webinar is being recorded for educational and training purposes. This recording may include questions and poll responses provided by you during the event. The recording will be made available after the conclusion of the event, and it will be posted on the firm's website. All right, so today's agenda. So for the next hour or so, we're going to walk through the CCPA, provide updates and insights. Many of you were able to join us earlier this year in May when we held a similar webinar, and we felt it very useful given the passage of only 3 months, but a lot of developments in California, to give a refresher. First, what is the CCPA? What has happened over the course of the summer? And what should organizations be doing to discharge their compliance obligations? We'll talk about other changes to privacy laws that impact compliance that ought to be considered, along with any discussion of the CCPA. We'll talk about enforcement now that the Attorney General Enforcement Authority has begun in California, as well as a private right of action and litigation outlook. And there have been a number of additional data points in that regard since our last presentation to you. And finally, we'll conclude with questions and answers, although I would just encourage all of you to submit questions as we go, and where appropriate, I will ask one or more of the panelists to jump in and address those as we get to them. So let's jump right into the substance of the presentation, and I will turn it over to Christina.
Well, good afternoon. Many of you are likely familiar with the CCPA. It is California's newest privacy law, but I think there's different levels of familiarity on this webinar with the CCPA, as well as compliance with the CCPA. The CCPA also doesn't stand alone. I think that it's easy to forget that California has a very rich history of data privacy laws, and even if the CCPA weren't in play, there's still a host of obligations that companies have in California as it relates to personal data. The CCPA does model some of the EU's general data protection regulation. Many of you probably went through the wave of GDPR compliance back in 2018. And I know that many companies have been sort of sitting on the CCPA, seeing what would happen both through the regulation process with the California Attorney General's office, as well as if the legislature would act and make any changes. But one of the things I just want to highlight before we go through some of the requirements of the CCPA is that a lot of privacy laws that have emerged, or sort of the context for how we have been engaging with user privacy, has been very focused on notice. And even in our practice, we know that many of our clients, understand their notice obligations, are applying their notice obligations. Where the CCPA has created some complications for compliance is, how do you honor consumer rights? So while it's easy to do the cosmetic fixes with the CCPA and provide appropriate notice, one of the things that I think we want to focus on today is you really need to make sure that as we are moving into the enforcement period, that you're ready to operationalize, that you understand what the obligations are for responding to consumer requests, and you make sure that your company is prepared and has the capacity to do so. And on that note, what are those rights? So these are 5 things that have been, covered in the news media and discussed, but, what do they mean day to day? The first one is the right to notice, which is having that external privacy policy. Many of you might have already undertaken steps to update your existing online privacy policy. If you have not, there are many requirements under the CCPA for what you need to give notice of and how you communicate with consumers. So one of the first places to start, we'll talk about a step-by-step process for compliance in a little bit here in this presentation, is to make sure that your notice is updated and accurately reflecting what the state of play is with data for your company to consumers. The next thing, which is something that is new to many companies who are just operating in the US and potentially serving California consumers versus those who are also operating in the EU and other foreign jurisdictions, is that consumers now have a new set of rights that a company has to be ready to respond to. One of those is that consumers can request and receive disclosures. So I, as a consumer, am able to contact your company and find out what data you've collected of me. And that is something new that many companies were not prepared for. Many companies had mechanisms in their privacy policies. If people had a complaint, like an email address or a mailing address to send in that complaint or that question, what wasn't in place was a meaningful system in order for individuals to request information about themselves. And accompanying that is also the right to deletion. So not only can consumers request what information you have on them, they also have a right to request that you delete that information. And again, you need to have a meaningful process in place to respond to a deletion request, but also to verify that, regardless of what your technology systems are, you can meaningfully and rightfully delete that information. The fourth thing that the CCPA puts on the table is the right for consumers to opt out. Many of us have probably seen on various websites that there are now those "do not sell my personal information" buttons, which we'll discuss that language and how those have to look a little bit later. But now consumers have a right to opt out of the sale of their personal information. And finally, the right to data portability, which is the idea that as a consumer, I can, get a downloadable version of my data, for example, and take it into another ecosystem, or potentially just have that downloadable version of data and have an archive of what your company has collected. So what's really important here is that as you draft new policies, whether they're internal or external, you also make sure that from a technology perspective, an operations perspective, and human resources perspective, that your company is really set up to honor these consumer requests. And given COVID-19, the fact that many people are working from home, we have been seeing an uptick in consumer requests. And so now that the CCPA will be meaningfully enforced, it's really important to make sure that you have these processes in place. Next slide. So who does the CCPA apply to? And many of you on this call probably have double checked this to see if you do have compliance obligations. But the one that I really want to focus in on, or the 2 points I want to focus in on, are whether or not the company earns a gross annual revenue in excess of 25 million. But I think more importantly and more applicable to a host of companies on this webinar and a host of companies who need to comply is if your company obtains personal information of 50,000 plus consumers. And for many companies, due to marketing activities, if you're in the technology space, mobile applications, if your targeting activities are focused at a wide group of people, you could easily hit that 50,000 consumer threshold. So, if you are in a growth phase of your company and trying to contemplate whether or not you should be complying with the CCPA, I know even at our firm, we have many clients who are in sort of this limbo stage of they're almost right there of having to comply. Now's the time to start thinking about that, because as growth accelerates, you want to make sure that your company's in a position where you're not scrambling to meet your CCPA obligations. Next slide. And it also doesn't matter whether or not you're inside or outside of California. I think this has been very confusing for companies who may have had to do GDPR compliance, given the scope of territoriality in the GDPR. But many companies are making an assumption that if they are not California-based businesses, the CCPA does not apply. And that's not the case. So if you are reaching California consumers, you really need to look at how many California consumers you're reaching. You also need to look at your revenue threshold. So just like any company that would be located within California, you need to still do the same type of analysis of whether or not the CCPA complies. Next slide.
Christina, it's Joe. If I might just ask you a question on that point. The law doesn't draw any distinction between the company that's in California or not, so long as it meets those thresholds that you've enumerated. But now that we've had some, albeit modest, enforcement activity in the form of letters to different companies, and just given that you're in Los Angeles and very cognizant of what's going on with that office, is there any sense that, notwithstanding what the law says, California companies headquartered based in California are going to be subject to greater scrutiny, or might be at the top of the AG's wish list? Is there any kind of discretionary feeling that you're hearing out there?
So I think there's two ways to look at the enforcement and who's likely to be enforced against with the CCPA. I think one would be to look at California-based businesses. Clearly, there was a groundswell here in California for more aggressive consumer privacy legislation. And because of that, we got the CCPA. And we'll talk about the next ballot initiative regarding consumer privacy in a couple minutes. So there's definitely a groundswell here, and there's definitely going to be a focus on California-based businesses. That being said, there are also certain industries that need to be cognizant about what they're doing. So one of the things that our AG's office often focuses on is sensitive population. So if you are in a particular industry where you might be dealing with sensitive consumer data, that's something you want to pay attention to. So it's really important not just to say, I'm not based in California, the AG's office is going to make a list of California businesses they're going to be enforced against first. I think that the AG's office is going to step back and sort of look at two buckets: larger California businesses that are collecting mass amounts of data, but also look at specific industries. And I think that leads into the next point that I wanted to make about some specific industries, which is I think there is an assumption many times that if you're already in a regulated industry, and what I mean by that is if there are already specific data privacy laws related to your industry, so the finance industry, the insurance industry, there's a list of industries that they have their own federal rules of the road for consumer privacy or individual data collection. That doesn't necessarily mean that you are exempt from the CCPA. And I think this has caused a lot of consternation and a lot of confusion among businesses because they assume that they are held at such a high level under certain federal laws, they must meet the requirements of the CCPA. But the CCPA could be applicable because it focuses on the type of information or the collection of information and use of information that could be different. So a great example is, it's been very attractive in the last year or two as you're collecting information about consumers, in your day-to-day course of business, there's all these new opportunities to market to consumers. There's all these amazing applications of data analytics. If you are starting to use the data you collect in a new way outside of the original intended purpose, you want to look to a law like the CCPA and make sure that is that new use of data triggering compliance with the CCPA. If you're starting to undertake separately just dynamic marketing activities, if your company is forming partnerships, or perhaps you have units that are collaborating with one another that never did before and sharing data, you want to look at those data flows and make sure that you don't have to comply with the CCPA. So one of the things that I'm really encouraging our clients to do, and as I talk to businesses, is, make sure that just because you have your, your rules of the road with your own industry specific data privacy laws, make sure you look at your data flows and see if the CCPA complies. And I think that's important, not just because of the CCPA, but this is sort of where the trends are going with privacy laws in the US as well as internationally. So it's important to understand what those data flows are. So even if you're in a regulated industry, you want to make sure that you have a good understanding of whether or not the CCPA applies to your business. Next slide.
Christina, I just wanted to jump into with an audience question about the threshold applicability, and that is whether that $25 million in revenue figure is limited to revenues derived in California, or is that beyond the state's borders?
That is beyond the state's borders. So it's important to understand that, again, I think that with state privacy laws, it's very easy to make an assumption that they don't apply to you if you're not located there, but there are things that can easily trigger compliance. So again, one, look at those thresholds. If you don't meet the revenue threshold, look at your consumer threshold, but two, also make sure that you are looking at your data flows, across your business and across your units. And the CCPA is not, emerging in a silo. And one of the things, and I referenced this before, is that California often leads the nation in consumer privacy and in other regulatory spaces. And the CCPA might not be the end of the road. One of the things that predicated the CCPA, was the threat, I suppose, of a ballot initiative. And so one of the questions that many businesses have been asking, but also I think why many businesses have been perhaps sitting on their hands with CCPA compliance is the CCPA going to change? The state of the law is now the state of the law. We'll talk about what emerged with the final regulations for the CCPA. Will the landscape of privacy regulation in California change? It may. And I say that because there is a ballot initiative that has qualified for the November 3rd ballot. When we met in our last webinar, that was up in the air and it wasn't clear it would meet the thresholds, but it did actually qualify through the California Secretary of State. So on November 3rd, we will have the CPRA ballot initiative, which has been dubbed as a CCPA 2.0. So if your business has not yet undertaken CCPA compliance, being a California resident, sort of actively following the trends as a resident as well as a lawyer in California, that ballot initiative may pass. If the legislature doesn't act and amend the CCPA or do something else, that ballot initiative has qualified. It may pass, which means that there will be another set of privacy compliance obligations you may need to look at. So, if you're sort of waiting to see if the dust is going to settle, it has settled with the CCPA. It's better to get in compliance with that law because you'll just be adding on to CCPA compliance should the November 3rd initiative pass here in California. Next slide. The next question I get, and I think one of the things I want to anticipate, after doing privacy compliance for so long, I think there's still sort of a laundry list many businesses are looking at for reasons not to comply with the CCPA. I fully appreciate, building compliance programs for businesses that this can be overwhelming, this is onerous, and there's always a question of, should I do it now or should I wait? I will say that over the last 8 to 9 months, we have seen more states approach consumer privacy and start discussing bills that either mirror the CCPA or model elements of the CCPA in some way. And just some of those states, which I think the reason I wanted to include a list here is some may be very surprising, sort of if you track regulatory movement in some of these states generally, but you have a diversity of states, Arizona, Iowa, New Hampshire, South Carolina. They're all debating different personal privacy measures. And I don't think this is going to be, the end of it. I think that as we approach 2021, I think as more companies and individuals are working from home, as data privacy becomes maybe more salient in people's day-to-day lives just due to work from home and school from home, I think we're going to see more of these bills emerge. So again, I think the CCPA has sort of been the leader here in the US for more recognition of consumer rights, embedding the consumer notice principles in different state laws. But I think a lot of states are going to look to the CCPA, for their model of what to implement in their particular state. Next slide. The other thing to recognize is it's not just the CCPA, it's not just the pending ballot initiative in California that, again, will just add another set of obligations with the CCPA. It's not just looking towards other states. There's also things that have been happening internationally. And I just wanted to spend a brief moment, since the CCPA compliance for many companies doesn't happen in a vacuum. It happens along with the GDPR and other international privacy regulations. One of the big things that emerged over the summer, and I think we'd be remiss not to mention this, it was a change with data transfers in and out of the EU. For those of you that have been, sort of glued to privacy for a while or doing privacy compliance work within your company, back in 2015, the EU Safe Harbor program disappeared, and it left many companies scrambling for how they were going to effectuate transfers. I'm not surprised that we're back at the drawing board in 2020, a mere 5 years later, and the Privacy Shield program, which in my mind, wasn't too far off from the Safe Harbor program that the EU courts had issue with, has also been invalidated. So one of the things that I want to point out, if you're going to be doing CCPA compliance and you thought your GDPR compliance was complete, this is something that you're going to want to re-examine. So if you are going to be going through an exercise of data mapping and how data is transferred, and you do have a presence in the EU, this would also be a good time to look at those data transfers and make sure that you have a legal basis for those data transfers. Next slide. And again, it's not just the US and the EU. I think that the CCPA and the GDPR are two acronyms that, we keep hearing about again and again and again, but they have been models for other countries adopting new privacy laws. Brazil for years has had in the works its own version of the GDPR, the LGPD. Canada is now revisiting its privacy laws. And so if you are doing business in South America, other countries are also looking to something like Brazil. If you're doing business in Canada, many people are familiar with Canada's existing law. It is expected to change and become more GDPR-like and more aligned to the CCPA. So again, by doing CCPA compliance, by revisiting GDPR compliance, you'll have yourself in a good position, for these other privacy laws. Next slide. So where do you start? In working with companies of all sizes, this is sort of the key question is, where do you start with compliance? You may have already done some compliance steps. You may just be looking at revisiting things now that the final regulations are actually in place. But I want to highlight a few things, just sort of a checklist, and then I'll turn it over to my colleague Steve to walk through some of this, of things you need to be thinking about. First and foremost, and I think this applies to any company of any size, is to engage in a data mapping exercise. We'll talk about what that means in a minute, but really, if you don't know what data you're collecting and where it's stored and how you're using it, you're going to have a difficult time meaningfully drafting policies and creating processes for CCPA compliance. The next step is internal privacy policies and internal data management. So I think before you put up the cosmetic privacy policy on your website, which I think is where compliance has stopped and ended for a variety of companies with the CCPA, make sure you can match what you're promising to consumers to an internal process. And that can be time consuming, workflows need to be created, trainings need to happen. But if a consumer request comes in and you really can't genuinely honor it, that's where regulatory issues are going to emerge, and that's where a consumer complaint is likely going to come from. You then will move to your external notices, which is letting people know how you intend to abide by these requests and what data you're actually collecting. Employee training is critical. This is new for everybody. And so whether it's just generally the employees at your company or the specific set of employees that you're training to handle consumer requests, it's important to make sure employees are adequately trained, have continual access to those resources. Vendor management is also important. One of the things that's been overlooked by companies in their CCPA compliance is looking beyond their own compliance as a company, as an insular entity, and looking to the vendors that they're working with and whether or not they're compliant in their transactions with them and whether those vendors are compliant with the CCPA. And finally, the security piece, which I think we'll touch upon, much more thoroughly when we talk about the private right of action. But, you could have this wonderful privacy program and not have the security in place for the data that you're collecting. So all 6 of these things interplay with one another, but I think this is a very good superficial due diligence checklist to get you thinking about what compliance should look like. And with that, I will turn it over to Steve.
Thank you, Christina. Now, Christina provided the list of all the things that the comprise of the privacy program. And I'm going to take each step one by one, and then we're going to shift over to security concerns and also litigation. So let's start with the data map. The data map is the foundational element to the business's privacy program. This is the high-level summary or annotation of the data flows into and out of the business. And why is it important to start with the data map? It's not something that the CCPA expressly requires, but you'll find if you start by saying, let's update our privacy policy, or let's do, let's start operationalizing requests as they come in, you might find that you just don't quite know, if it hasn't been conducted yet, where the data is in the business. And so oftentimes we find ourselves in matters going back to square one. Do we have a data map? Has it been done? Has it been updated recently? And so one of the things to update, since now the CCPA regulations are final, maybe you've conducted a data map. What are the things you should be focused on as it relates to the data map? Keep it current. As you onboard new vendors, as you create new products or launch new products that do new things with data, perhaps to adapt to this new COVID environment and maybe be contactless. You're obtaining biometric data for the company and using it in new ways. Keep the data map top of mind. It's super critical, and in terms of identifying and helping to spot gaps where the business should be identifying what laws might apply based on collection of new data. So that's top level why a data map is so important. Now, what is included in a data map is pretty much as follows. You have basically the data type, the data collection process, how it comes in, the flow of the data, where it goes, and the transfer path for the data, the storage location, and think physical and the digital storage, where is it located, which cloud providers is the data maybe archived with, if there are any protection or security controls in place for the data map or the data inventory typically lists that. And also a good data map will also include the retention periods and destruction protocols that apply to the particular data. And finally, it's also a good time, a good thing to include stakeholders in the data or in the data map so that you can identify who touches a particular data. And as we go to the next slide, you'll see a sample data map. It might be small for some, but if you can see, it basically, what form or format does a data map take? It could be a simple spreadsheet. There are more complicated or maybe more complex data map softwares that are available. Obviously you should adjust to what's appropriate for your business. But if you're starting from nothing and you have the ability to just put it into a spreadsheet, that's also, someplace that we often recommend starting there. And so from the data map, we can now pivot to the other elements that comprise our data processing or data privacy program. For example, this helps us to identify to what extent we can operationalize and create processes for consumer rights and acting on consumer rights. And so with respect to the consumer rights, you want to make sure you can, as I said, operationalize or act on what they're called subject access requests, consumer rights requests. You're going to see that they're going to be called different things depending on if you're talking to someone that's also knowledgeable about the GDPR or how long the data program in a particular company has been around. But you just want to make sure that the company has a procedure in place for handling subject access requests, at least under the CCPA, within the timelines prescribed. So for the CCPA, if it requires 45 days or within a certain period of time of confirmation, 45 days to act on the request, and under certain circumstances, the business can ask for an additional 45 days. If you have a global privacy program, you may want to adjust that a bit to anticipate for a particular law that applies to the business that has a shorter period of time. Take, for example, the GDPR. In the GDPR, the law requires businesses to act on requests within 30 days. So if you're going to marry the two together, then your internal process and program will perhaps require the business act within 30 days, even though the CCPA would allow for 45. And kind of tying back to the data map is going to really help to identify where is the data and who are the stakeholders that need to be involved in the process of reclaiming the data. Oftentimes when we work on matters in building out the data request process, we identify which of the particular parts of the CCPA apply. Is the business selling personal information with third parties or not? If it's not, then we can focus on the right to know and the right to access and the right to deletion first and foremost, and craft a policy and program that identifies those requests and handles them accordingly. And
Steve, just a kind of a concrete illustration of what an artifact might look like that's part of this process you've just described. And we've done this for a number of clients, both prior to January 1st and thereafter, and that's creating just written workflows that really spell out the kinds of things you're talking about. What kind of describe that so that the participants have a sense of what that actually looks like when you move to implement one of these?
Sure. Envision basically steps, a workflow. If a request comes in, it goes to the intake part of the whole program. Maybe it's customer service because they're really good with dealing with customers and handling customers. And so you can provide them a script. And then, depending on the type of request, it then flows to perhaps the lead of the team who then quarterbacks the handling of the request. This process could be automated based on the workflow that's created, or it could be handled manually depending on how many requests are received by the business. Some vendors offer a way to handle this. You can handle it through a vendor or you can handle it in-house. There's different ways of approaching this. But again, it's something that businesses have to do in order to demonstrate compliance with the CCPA. And part of that is creating records of the responses to requests and having those template formed responses. And getting the timing right is important because then you could demonstrate it in an audit trail that a request was received on a certain date, it was responded to within the prescribed time, and that this was the request, or this is what the final outcome was, and then the case was closed. So that's pretty much the beginning and the end from a top level of the consumer rights request process. Next slide. Next, as Christina alluded to earlier, the CCPA includes educational requirements. This includes pretty much the team that handles these consumer requests. That team must be educated on the process, the CCPA requirements. Customer service, if they're the ones handling these requests, they have to know how to handle these requests, what the requirements are under the CCPA. Whereas this is something new, again, that businesses are dealing with. Exactly how training takes place is really up to the businesses, but it just generally should obviously correspond and align with the CCPA's requirements. Next slide. For those that are seeking CLE credit, a little timeout here. The code for that CLE is 5TMP4DX3K7. Next slide. Next, a big part of compliance with the CCPA for businesses these days has to do with vendors. And under the CCPA, it's important to understand who it applies to. The CCPA talks about 3 different types of entities: businesses, service providers, and third parties. Any one of those could collect or process personal information under the CCPA as it relates to California residents. Of the 3, the CCPA mainly imparts obligations on a business, and that's really what we're talking about. We're talking about the business's obligations. But a company can be both a business and a service provider. And nothing in the CCPA precludes a dual designation. And in fact, the regulations confirm or provide that a service provider that is also a business must comply with the CCPA's requirements with regard to the personal information it collects, maintains, or sells outside of its role as a service provider. And finally, a third party is an entity receiving data that is neither a business nor a service provider. So it's a kind of a negative definition of what is a third party. So it's important to identify whether your company fits one of those definitions or a mix of both, because businesses in particular, they must make certain representations in their contracts between vendors that qualify as service providers. Because if they don't, they otherwise might, that transfer of data with that particular vendor could be considered a sale, and it creates a host of obligations for the business if they're otherwise not anticipating that they're not selling data, or that they are selling data under the CCPA as that term is defined under the CCPA. And among those obligations includes, as Christina alluded to earlier, the installation of a do not sell my personal information link on a business's homepage or in their mobile app if they have one. Next slide. There are other reasons in addition to the CCPA's express requirements of what needs to be in a written agreement between a business and a service provider for requiring or wanting one between your business and your vendors. And we're seeing an increase in, obviously, a groundswell of contractual obligations between basically the entity that controls the collection and processing of personal information and the entity that acts on that request. Or, and sometimes the entity that's joined with the other business, like a co-business, they're working together from a pool of information. And so some of these reasons include liability shifting. In fact, that's one of the driving factors for many of our clients in terms of wanting to make sure that the written requirements are in a particular vendor or master services agreement, to make sure that in case that particular entity they're doing business with violates the CCPA, they have a contractual liability shifting mechanism they can fall back on. And this exists for both service providers and certain liability shifted third parties under the CCPA. But again, there's very specific terminology that needs to be used as it's laid out in the CCPA's express, in the actual legislation to include in these contracts. And so oftentimes what businesses are doing is they're creating templates that have this language. They're revising their existing agreements, or they're including it in new agreements so that they can otherwise check off that box with CCPA compliance and know that at least they can demonstrate that they have the provisions in their existing agreements or pending agreements with their business partners. In addition, CCPA aside, it sometimes is a good idea to place limits on other businesses' use of personal information, particularly if your business is the one that is responsible for collecting and using the personal information. From a good due diligence or governance standpoint, it is increasingly more and more important for businesses to get a handle on the data that they are in charge of. And so it otherwise is a good idea to include certain provisions in their contracts with vendors. Next slide, please. And when I referred to the language that must be included in CCPA contracts in particular, or contracts that are in line with the CCPA, that includes prohibitions from service providers selling personal information, as that term is defined, retaining, using, or disclosing the personal information for any purpose other than the specific purpose of performing the services specified in the contract. And the law also includes a requirement that the parties certify their understanding and compliance with the CCPA. Next slide. So what happens if your business is also a service provider, or your business is primarily a service provider? Well, the company also has CCPA obligations, but they're much more limited. And in particular, it's very important to know which obligations you have, whether or not you are selling any personal information. Let's say you don't have that magic language in your contract with a vendor. It could be considered a sale. And so before you use that data with another party, a third party or a vendor, you may have to notify the consumer of the right to opt out. So think software as a service company, cloud service provider. Those are the classic service providers as anticipated under the CCPA. Next slide. So how should service providers handle third-party requests? Not just deletion requests, but also, give me a copy of my data. Well, the regulations make clear that service providers have options. You could act on the request, or you could tell the consumer you cannot act on the request because you are the service provider in this relationship. And most of the time, or increasingly, we're seeing contracts dictate whether or not the parties should include a notice to the business if the vendor receives a request from a consumer. So it's important to think about these issues in advance, particularly as you're entering into a new relationship with a vendor, or re-identify or exploring current relationships to see if you need to update your current contracts. And it's also important to keep a record of the response to the request, so you could also provide that to your business partner if you are either required to, or if it's advantageous for you to do so. Next slide. And so just a few compliance statistics. And Christina, I'm not sure if this was where I was handing it over to you or not, but just jump in if so. But as of around April 2020, which is when this survey of privacy professionals by a vendor named Truio, which is owned by IBM, was conducted from over 1,000 employees surveyed, 51% were actively receiving consumer requests. At least based on my practice and the practice of my colleagues, I know we can expect that number to actually have increased, especially after July 1st. 56% expect an increase in requests due to consumers staying at home and working from home, which we, since this time, have actually can confirm, at least in personal experience, that to be true. And 51% find honoring CCPA requests to be the most concerning part of CCPA compliance. Why is that? Because this is where, if a consumer has a difficult or a troubling time with a particular business, they could complain to the California Attorney General, which then could invite an investigation by the regulator. Next slide. And in terms of costs, I think, Christina, this is where I was going to transition over to you.
Thanks, Steve. One thing I want to just point out very quickly, and then we'll move very fast into enforcement, since I know that's a topic on everyone's mind. There's been a lot of reticence to comply with the CCPA. I think everyone appreciates that it's there, that there are certain thresholds that need to be met, things need to be done. But when they find out what's involved, and we've detailed a lot of steps that are involved, sometimes there's an action. And one of the things I just wanted to sort of put out there is, this is not one size fits all. We work with companies of all shapes and sizes, very small startups to Fortune 500 companies, and doing privacy compliance work. And really, we sit down and figure out a roadmap and help our clients, get to their compliance goals. But it's just important to understand that this is something that, if you're doing business in California, there's a cost to doing business in California. If you're collecting consumer information from Californians, this just now needs to be factored into your cost of doing business. And so I shared this information because this is something that the AG's office had an independent research group sort of decide or figure out what the figures for compliance would look like. This is what we're seeing. This is very reflective of what we're seeing out in the marketplace. So I just wanted to share this information, as you might be thinking about what costs of compliance could be. Next slide. So CCPA enforcement, I'm just going to highlight some final regulatory changes and then pass it off to Mike to discuss enforcement. So the final regulations were approved on August 14th. That is something that we were waiting for to see if there were going to be any huge changes to what we had seen in the modifications that had been released earlier in the year. These regulations are now into effect. So if you've been sort of waiting for this to come into play, and many companies thought this wasn't going to happen until October, it happened 2 weeks ago. These are now the final regulations. So if you've been waiting, now's the time to move forward and take action on the CCPA. And just to remind everyone, the CCPA does have a look back period. So, if you were waiting until the enforcement window July 1st, and then you were waiting until the final regulations were passed, just be aware that the look back period actually does go back to January 1st, 2020. Next slide. So quickly, just 4 changes that came out in the final regulations. We will distribute this later so you can review it. One is that consent is not required for materially different uses of information. So you're no longer required to disclose if you're using the information in a different way than at the time of collection. Use do not sell my personal information. Some companies wanted to get crafty and come up with different ways to disguise this link and not make it as obvious to consumers that they had a pathway to ask a company not to sell their personal information. You have to use this language. So even if you thought you were making it more accessible to consumers, this is what the Attorney General's office wants you to use. They want you to have that do not sell my personal information language on the opt-out link. Next slide. Offline notice was set aside. One of the things that businesses that were both online and brick and mortar were having trouble with is how to give that offline notice to consumers about data collection. As you can see here, that's no longer an issue. And finally, the thing that might make you feel like this was a give to businesses, but really I don't think it was, is that there's no requirement that the opt-out process be easy for consumers. That being said, I think Steve made a great point a couple minutes ago. If it's not easy and there's roadblocks, consumers complain. So it's better to make your process accessible and efficient and responsive versus trying to make it an obstacle for individuals to opt out of the sale of their personal information. And with that, I will hand it over to Mike to discuss enforcement.
Okay. So I noticed we had a question in the chat, which I think is not a bad way to start the enforcement section. So one of our observers here asked, what is the status of litigation or expected litigation to be filed to challenge the extraterritoriality of the CCPA under the U.S. Dormant Commerce Clause, the Dormant Commerce Clause of the U.S. Constitution, and or other legal bases? Okay, so a Dormant Commerce Clause challenge would be essentially saying that California has overstepped its bounds and is now burdening interstate commerce. I am not aware of a current case. I certainly could see litigation being filed, and who knows, this is the kind of thing that you might find in this statute. I mean, it is a very poorly drafted statute that was done in a rush after a referendum. So it's like a piece of buggy software. There's a certain amount of things that allow for cases, and people could think about amicus challenges of certain kinds. I personally am skeptical as to whether or not this kind of a challenge will actually do anything. I think, to cut this short, we're still going to have to worry about enforcement. We're not going to be able to knock this out of the box. I have not specifically researched this, so you're going on some old constitutional law knowledge as best I can here, but essentially the really good Dormant Commerce Clause cases are the ones where a state is being protectionist against another. So let's say California says, hey, Kansas wheat, we're going to jack up the price to sell Kansas wheat in California. Well, that is protectionist. And that's a no-go. I mean, basically from the time of Chief Justice Marshall and the Ogden case. Ogden against Gibbons, I think. You get to now the other thing of, oh, well, is this just overly burdensome? There's the burden on national commerce, and it outweighs local benefits. it's not a formalist analysis. Long story short, I think this law will stand up. It's being equally applied to California businesses and non-California businesses, is responding to a very politically popular need for additional privacy. Never mind whether it's actually a good idea or whether it defeats the things it's trying to achieve. Certainly the desired benefit is real. So I think we have to deal with enforcement. And now we come to our slide. What will CCPA enforcement look like? Well, there are two pieces: public litigation and private litigation. Now, the first piece is done by the sort of default regulator in California, and frankly in all states, which is the state attorney general. Now, there are a few interesting things about this. It's not a regulator devoted just to this statute or to these needs. This is a regulator who is a general regulator with many other priorities. I have no doubt there'll be particular people, particular line prosecutors tasked with enforcement of this statute. And to the extent that things are interesting and press-worthy, you are more likely to get attention. People in government don't always like to admit this, and I'm a former federal prosecutor, as is Joe, but the truth is, press does affect government priorities, especially for elected state officials, I might add, but even with federal prosecutors. I mean, I don't think it's such a surprise that the federal prosecutors in New York are chasing certain kinds of cases that have to do with Trump. There's a lot of press that goes along with that. So, putting aside any merits of any cases, that also suggests ways in which you should think about public regulators, in that if you are doing things that are especially interest or newsworthy, you will get more attention. Or if you are already in front of the state regulator for other purposes, let's say they're looking into trading of securities by a broker-dealer or other better business practices, this is now a new thing they can look into. So once you already have scrutiny from a regulator that has a lot of other messages, this is something they could turn into. But at the end of the day, they are a little bit resource constrained. As far as I know, there has not been some doubling or tripling of the California state AG, and nothing of the sort is envisioned. And so this is real, and if you're getting looked at, it can be added. And if you are especially attractive as a press target, you may get scrutiny. But the biggest thing you have to worry about is the second bullet point, private litigation. Because there really aren't resource constraints. This is individual people who are looking to make money by suing you, basically. There are individual aggrieved customers, but there's also the plaintiff's bar. And in particular, class actions, which is a way that lawyers can start cases with only a person or two, and then eventually recover on behalf of a very large group. And that, of course, creates financial pressure. So the private right of action is the place where a lot of regulation will, as a practical matter, take place. Next slide, please. The last thing I should say, keep it on this slide though, is that the fact that you are regulated by another entity, let's say the SEC at the federal level, doesn't protect you from this private class action. So Christina mentioned earlier how the CCPA is a kind of floor, or rather existing regulation acts as a floor, and the CCPA is on top of that. It's a bit of a ceiling. So if you're regulated by HHS, Health and Human Services, through HIPAA, the CCPA does not cancel out HIPAA, it adds on top of. And if HIPAA is occupying the space, then the CCPA will not occupy. But if there is an area that HIPAA doesn't touch, CCPA falls into the gap. So that's another way to think of the private rights of action, is that you are not going to just have to deal with your existing regulator. You're going to deal with a private person exploiting some pretty buggy software here, a poorly written statute, and going for it. And this slide shows you what they're going for. It's got a few different elements it's worth looking at. We're going to go through it. First of all, it says any consumer. So who can sue under the CCPA's private right of action? Any consumer, not another business, not another corporation, but a flesh and blood human being. They can sue when their non-encrypted and non-redacted personal information is subject to an unauthorized access. Okay, so this is a small piece of good news here. Actually, not so small, pretty darn significant. Encryption is a safe harbor. This is true under all the data notification statutes in the 50 states, actually. Encryption is a safe harbor. So your decision as to what you will encrypt is very important. This also gets back to the data map that Steve was talking about earlier. What are you encrypting? What are you not? There are business needs. Encrypting and decrypting things can be a pain in the tuchus and slow you down big time. But sometimes it's essential. And what happens is if a bad actor gets into your system and takes a peek at something, but it was encrypted so we couldn't really take a peek, you don't have liability. That's great. That's one of the reasons why you have to think about what you encrypt and don't. I notice I said access. The next word is exfiltration. It's just a technical term for theft, basically. But the point here is they don't actually have to have taken the data. An attacker doesn't actually have to run away with it. If they just break in and they've taken a look, that's enough. And so the typical problem that we get in data breaches, I handle data breaches, so is everybody on this call, basically. And one frequent question is, well, are we sure they looked at it? Or rather, can we rule out whether or not this data was accessed or looked at? And so this statute follows that pattern. Okay. And the next piece is, right, because we've done any consumer whose non-encrypted personal info is subject to an unauthorized access or disclosure as a result of the business's violation of the duty. So there's a causation issue and it gets tied to the duties under the statute. These duties to set up and maintain reasonable security practice. Okay, next slide, please. So, breaking it down further, said personal information. That's another aspect. What is personal information? Well, it's stuff about flesh and blood humans, first of all, is your quick way of doing it. And then there's a series of definitions. Many states have different definitions of what personal information is. And other parts of this law have broader definitions, but in the private right of action, it's closer to what California had before. And so, you know, name, either first name or initial and last name, and a data element. Classic is a social security number, but it could also be unique biometric data, things of that nature. And again, if it's encrypted, no private right of action. Next slide, please. Okay. In some ways, this question, what is reasonable security, is essentially the central question of all cybersecurity law. What constitutes reasonable security? And the answer, as always, with a term like that, is a very lawyerly answer of it depends. But the important thing to notice, too, is it changes over time. What's reasonable in 1 year may not be reasonable 5 years later when there are new attacks out there and new things are considered market standard, right? So way back in the ancient days when you only had a password and no extra element of authentication, like a code through a RSA key, a randomized number, any other element of two-factor authentication, it was okay to just have a password. Quite clearly at this point, you better have two-factor authentication as a darn near minimum for reasonable security. That's one example. Just notice that this is a continuing obligation basically to stay up to date and to stay market. What are other people in your industry doing? There are other sources too, because heaven knows this isn't very well defined. So in 2016, the Office of the Attorney General put out a data breach report, which points to various frameworks you can use to help you figure out what reasonable security constitutes. And I have them listed here. The Center for Internet Securities Controls, the NIST framework. NIST is the National Institute of Standards and Technology, great national group, that engineering standards, and the ISO 27001 standards. These tend not to be simple checklists. They seem to also be collections of principles. I mean, NIST took its principles from other existing principles and collected them. So it's not as if this is an easy plug and chug. It's a place that privacy professionals dig in and help you extract things. But when you do have something that a regulator has specifically flagged for you, you got to pay a lot of attention to that. So I remember, I mean, I do a decent amount of work for investment advisors, and the SEC's investment management division put out a list which actually had some very specific measures. I mean, certain basic things like have a firewall. That's a pretty good sign. Another place where you would derive it from would be litigation. And to a certain extent, we'll see what happens with that. Next slide, please. So I don't know if, in terms of what steps we should take, well, we've talked about it before. You got to go through the standards and try to devise it. I think I'll skip this for now because that's kind of a conversation we would have that's more specific to each person. Steps you should take, well, have reasonable security procedures and practices, get your data map, encrypt and redact as much as practicable. Just want to emphasize very quickly, that is not just a compliance decision. Talk to your business people. If you set up an encryption procedure that doesn't work for people, they're going to go around it and try to defeat it. So as with all things in cybersecurity, you can't just lock it down for compliance. You got to talk to the business people and see what people are actually going to do. Because then you'll end up with bad security because people will have on paper great security that they don't follow. Next slide, please. Okay. Just need to mention, why do we care about the private right of action so much? Well, because it's a huge amount of money that can be at play. The statutory damages of $100 to $750 per customer per incident, or actual damages, whichever is greater, okay? So you can have these harms which seem technical and ridiculous, but the statute says at a minimum $100 per. Obviously that adds up if you have a lot of customers. If you have 10,000 customers, the penalties can range between $1 million and $7.5 million. If you have 1 million customers, $100 million. And of course, you can get attorney's fees. Next slide, please. Trying to move through this. Okay, there's a notice and cure provision. Basically, what this amounts to is the plaintiff has to give you written notice that identifies the specific provisions of the title that they say are being violated. As a practical matter, this isn't going to change a lot. Curing this is not so easy, but it's kind of like you get an extra 30 days to set up your case and get ready for it. Next slide. Let's see here. Okay. Yes, limited benefits. And, oh yes, if you are attempting to cure and take advantage of this cure provision, just remember that you are making a statement on the record, you live your life on the record, and in the future, you're kind of admitting, oh, this is something I should have done. Maybe you want to do that. Obviously, very case specific. Got to think about it. Next slide. Okay, so here we are. I think, Steve, you were going to contribute on this one. But and I'm not sure if this is completely up to date today in terms of how many cases are filed, but quite clearly, we are already seeing CCPA litigation. Despite COVID-19, despite the fact that the regs are just, fresh out of the oven, we already have the private lawyers chomping at the bit, which again emphasizes that as a practical matter, that's where a lot of the enforcement is going to come from.
Yeah, Mike, the case numbers are actually current through the end of July. There are over 40 cases, and they fit under pretty much 3 buckets as they're identified here. You have data breach security cases, which you discussed, and those are the cases we anticipated seeing. But what we didn't anticipate, and we're seeing nevertheless, are plaintiffs filing cases without complying with the notice and cure 30-day obligation. And so some of those cases are testing the waters if it's a breach that happened before the new year. So there's a kind of a myriad of variations to these kinds of cases that we're keeping our eye on, and we're seeing all different types. Then the second bucket is the data privacy cases. That's the case against Zoom, for example. Zoom didn't have a hack or a breach, but people were not happy when they found out that their data was being transferred to Facebook and they weren't told in Zoom's privacy notice before it was changed. And so there was litigation that ensued, or if there was some Zoom bomber that came to a meeting. And so these are the cases that we know that plaintiffs don't have standing to bring these actions, but yet they're being brought under creative theories and causes of action. And so the Attorney General has actually already announced and indicated that they're interested in inserting themselves in some of these cases to inform the court about what it understands its role to be in these civil litigation cases that are pending. So we're obviously very, very interested in keeping our eye on those cases. And then you have some cases that have miscellaneous references to the CCPA. It's not a case that's brought under the CCPA, but it certainly informs the importance to the right of privacy. You're often seeing these in cases that are not California per se, but it's where the plaintiff is talking about the trends of privacy being more important in our daily lives and these new laws that are coming out. So it would call it the miscellaneous references to the CCPA. So those are the kind of three buckets that these cases have fallen under.
These numbers are increasing by the day, and back to the question somebody asked a few moments ago about the Dormant Commerce Clause. I suppose that could be asserted as some kind of a defense in one of those actions. Suppose it could also be the basis for a declaratory judgment action. We've not seen anything like that, but Mike, you made a great point earlier that as these statutes proliferate in other states, the notion that California is sort of being unduly harsh is going to, frankly, go by the wayside because other states are in the process, as Christina pointed out, of passing their own laws. And in fact, California may pass one that's even more stringent than what we're dealing with today. So we have, it looks like one other question that just came in asked to repeat the CLE code. I will get that and we will provide that. And then I would solicit anyone else to send us a question. We've answered the others that have come in along the way. And otherwise, be on the lookout for a thank you email from us, which will contain today's recording as well as the PowerPoint, which has all these details that we've gone over today. Please leverage those and reach out to us with any questions. Our contact information is there. The CLE code is 5TMP4-DX3K7. And I think that will be in the deck that's circulated thereafter. So again, thank you for participating. Thanks to my colleagues for leading this webinar. And I hope everyone has a good afternoon. Thanks.
Hey, everybody.